We are live. Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Thursday, April 6, 2023 at 9:04 in the morning. So we're here for the first half of the morning to take some more testimony on H121, which is an act relating to enhancing consumer privacy. So with us this morning, Gary, thank you for joining us this morning. We appreciate your time and look forward to your testimony.
Well, I appreciate the opportunity. I'm not exactly sure how all this is supposed to work, so just give me some guidance on what you want from me, and I'll do my best to give you what you need.
Well, I think I think we're just looking for some comments on the bill.
Okay.
Your experiences that you've had with data privacy that can help inform the committee.
Okay, well, I can briefly tell you what got me involved in all this. It won't take much time. A couple of years ago, I started receiving emails from a company called Carfax, Carfax. And in those emails, and these were unsolicited emails, I am not a subscriber to Carfax. And in these emails, they would describe services that I have had done at Heritage Automotive Group, or services that were due and upcoming, or when my registration was due. And I didn't understand where these were coming from. I contacted Heritage Automotive Group about this, because it says right at the bottom of the emails that the information was being provided by Heritage. And I got a response from Heritage, and they said that Carfax has a partnership with dealers to share vehicle information that is not public information, but is accessible between dealerships and Carfax subscribers such as yourself. Well, I'm not a Carfax subscriber. So, the Carfax company has my name, my address, my email address, my phone number, my VIN number, the make, model, and year of my vehicle, and all of the services that have ever been done on my vehicle. And I did not give Heritage permission to share that information with any third party. So that's what got me going on this. So I looked up what consumer protection was available at that time. And the only thing I could find on the statutes was that residents of Vermont have a right to be told when there's a data breach, but we really don't have any control over our own personal data and information. I then contacted my local representative, who at that time was Maida Townsend, and I tried to get the ball rolling with getting something done from a legislative perspective, and here we are today. So that's been my experience. Companies in Vermont apparently can take their customers' data and do whatever they please with it. And I think that we as consumers, who I think are the owners of our data, should be able to have a little bit more control over how that data is used and who it's shared with.
That's kind of it. That's interesting. It actually just brought up something that I hadn't really thought about, but when I just took my car in to have it serviced, have the oil changed, and a few days later I received a letter from XM Radio that I've got a free 3-month subscription, and it was from the auto place repair place where I brought my car in to be serviced. So they must have a relationship with XM to provide that data. So I hear where you're coming from.
Yeah, and then further, Carfax and whoever else out there may have my data. I don't know what Carfax is going to do with it, or what other businesses in Vermont may have my information and are sharing it with third parties. So, I would just like to see that us as consumers, as residents of Vermont, would have a little bit more control over who can get their hands on our information and what can be done with it. So, and I do have some observations about the draft bill. And do you want me to just go into that, or do you have? Okay. Yeah. In the definition section of data broker, as it's written, the definition is a data broker that sells or licenses personal information. I think there should be broadened to provides or shares, because if a company is providing data in exchange for something of value, other than money, that should be covered as well. For example, if a company provides data in exchange for a reduced price on a product or a service, or in exchange a barter, as you would for a product or service, and no money changes hands and no licenses involved. So I think that should be covered as well, not just selling of data, just the plain sharing and distributing of our data. In section 2432E, the rights of consumer section, the consumer right to opt out of processing of personal information, I don't think should be limited to there's three activities listed there. I think the consumer should be able to opt out of the processing of their information for any purpose. In the data broker's additional duty section, 2448, individual opt out, right now it reads the consumer can request that the data broker stop doing. There's certain things that are listed there. I think the consumer should be able to require the data broker to stop doing the activities that are listed in that section. And further, I think the opt-out should not be limited to selling consumer data, but the requirement should be broadened to something like stop sharing or providing consumers data.
Okay.
And I sent my observations to Mr. Haggerty, and he said it was posted on your website. So you've got it in writing now.
Okay. Any questions for Gary? Great. Gary, thank you for speaking with us this morning. We appreciate your time. And, I think all the information we gather helps us to try to put something together.
Well, I'm glad that the legislative body of Vermont is addressing this issue, and I hope something of fruition comes to that and gives us greater protection and control over our personal information. So I appreciate your time, and if there's nothing else, I guess I'll leave you guys alone.
Thank you very much.
Thank you.
So Chris is on Zoom. Chris, good morning.
Control over our
Chris?
Yes.
Good morning.
Good morning. I appreciate you taking the time and letting me address the body.
Well, thank you for joining us this morning and taking some time out of your schedule to chat with us this morning about H121. So we look forward to hearing your testimony.
Thank you. I'll try and keep this brief. My name is Chris Gilrain. I represent TechNet in the Northeast. We are a industry association representing about 100 companies throughout the innovation ecosystem. This is companies from search, marketplaces, autonomous vehicles, electric vehicles, advanced energy, fintech. It's a broad umbrella, and we want to present our opposition here to HB 121 as drafted. If I may, I'd like to begin with subchapter 6 and then go back to the beginning. As a former legislative staffer and current tech policy professional, I totally understand and sympathize with the fact that technology evolves faster than the legislative process can keep up. Frankly, that makes it all the more worrisome that Vermont would consider regulating consumer activity in 2023 with a model statute that was passed when I was just starting to get email on my BlackBerry for the first time. Passed in 2008, Illinois' BIPA has not been a boon for that state's consumers. Because the statute, like HB 121, does not include an exemption for pro-consumer uses of biometric information, like preventing fraud and abuse, companies simply don't offer those services in that state, leaving residents more exposed to hacks and identity theft than their neighbors in other states. I think that's part of what gets lost in the discussion of this technology. Biometrics, by and large, are not being used as some dystopian plot. They're being used because they're significantly more secure than an alphanumeric password that we usually use. Banks confirming your identity with a voice print when you call to report a stolen card or transfer money, smart devices that can dispense medicine safely based on a thumbprint. These things help keep us and our neighbors safe. I heard a commercial the other day for a video doorbell that could be programmed to alert you if the person at the door was recognized as somebody who's on a pre-populated list of people you know that you can program into the doorbell. Disclaimer at the end, like a lot of products, says not available in Illinois. Now, you might be saying, I don't care if my doorbell recognizes the mail carrier or my brother at the door, but to somebody who's vision impaired or otherwise has trouble getting to the door, that's a game changer. And that's not the only cost of BIPA in Illinois. More than 1,100 BIPA-related class action lawsuits have flooded the courts in the last 5 years alone. And by and large, the targets of that litigation are not major California-based tech companies, because as we discussed, they pulled their products from the shelves. But usually it's small local businesses that are alleged to have used biometrics in some internal, usually human resources purpose, like scanning, giving employees the option to scan a thumbprint as opposed to putting in a PIN when you time keep in and out. Small businesses in the state report that the cost to achieve a successful motion to dismiss, whereby the definition is there is no merit to the case, was up to $1 million in legal fees just to get it dismissed. This has created a cottage industry of settlement-seeking lawsuits that provide a nice living for the plaintiff's bar, pennies on the dollar for the average Illinois resident who is a member of that class action, and devastating liability for local businesses. We categorically oppose any legislation based on BIPA. There are, however, data privacy models that do help safeguard people's biometric data, and in fact, all of their personal data that is collected by companies. Some of those models are reflected in subchapter 1 of the new section 2433 of HB 121, but because it's bolted on to an expansion of the data broker registry and the BIPA section, the total result is confusing and actually still incomplete. I've been watching the testimony and heard this bill referred to both as a Frankenstein's monster and an incremental step. And from a compliance perspective, neither of those things are very good. If enacted, HB 121 would cost businesses large and small a significant amount of money to build out compliance infrastructure. It'll have to be a custom solution for the state. And there's nothing off the shelf that's going to meet the needs of what is envisioned in HB 121. And when it's all said and done, after it's implemented and companies foot the bill for compliance attorneys, Vermonters will have some of the rights guaranteed to their peers in Virginia, Colorado, Connecticut, and elsewhere. And businesses will be liable for another bill when we take the next incremental step. If a room full of policymakers and lawyers are having trouble parsing what sections apply to which controllers of data and what hope is there for the local coffee shop owner to come into compliance, or the average citizen to understand their rights and how to exercise them? The beauty of the data privacy laws in places like Virginia, Colorado, Connecticut is that it is both comprehensive, includes strong consumer rights, transparency, and security for all personal data, plus deeper protections for sensitive data like biometrics, and they're clear. Customers understand their rights, companies understand their responsibilities, and the Attorney General is empowered to investigate and punish violators. If TechNet were to make a suggestion to the committee today, it would be take the time to work on a comprehensive bill that is interoperable with these existing state models. You would not be alone. The New Hampshire State Senate just passed a bill based on Connecticut's model last month, and we expect the House is likely to consider it in the coming weeks. Rhode Island has similar bills in both chambers, and Maine is getting a slow start, but they are following suit. And it makes sense, particularly in the Northeast, where we can be crossing state boundaries every couple hours. It makes sense to have a privacy model that covers people in a regional way, that gives people clarity on what their rights are and how to exercise them. And it reduces the cost of compliance to Vermont businesses. So we hope to work with the committee to move toward something that is more comprehensive and interoperable with existing state models. And we hope to be a resource to the committee. Appreciate your time.
Questions for Chris? Edie?
Hi, Chris. Thank you. I have a couple of questions. You said that you're opposed to the biometrics section and anything related to biometrics. And then you said something about biometrics being covered in another section. And so I'm not 100% sure what you mean by that. So if you would be a little more clear, that would be great.
Absolutely. Yes. Thank you for the question. So under the comprehensive privacy laws that I mentioned in places like Virginia, Colorado, Connecticut, there is a baseline coverage for all sensitive data or for all personal information. And then there are additional protections for sensitive data. Biometric data is one of those things that is under that umbrella of sensitive data. And so that receives another layer of protection, and it's required opt-in and data protection assessments. So that's the model for protection of biometric data that we do support, as opposed to the Illinois BIPA model.
Thank you. And then if I may, one more. What is it specifically about the biometric section that is just, I don't know, just difficult for you? I mean, for me, when I read it, it says if you're going to retain and collect it, you have to be clear about what you're going to do with it and how you're going to use it and have a time schedule on when you're not going to keep it anymore. So I don't understand what the difficulty with that is.
Yeah, and those provisions again are included in those comprehensive bills that I referenced. The problem with BIPA is the vagueness of the definitions, which I will acknowledge have been sanded a little bit in HB 121. The real problem is the private right of action with statutory damages that has led to those 1,100 settlement-seeking lawsuits. We think that it's complicated. It's a complicated area of law, and the Attorney General is the best suited to deal with it. And that's the way it's done in the comprehensive laws.
Thank you.
Questions for Chris? Jared?
Hi, Chris. Jared Sanis, representative from Castleton. So you mentioned that New Hampshire has a privacy bill that was based off of Connecticut?
Yes.
Okay. So that's definitely interesting. One thing our legislative body's been working towards this session is developing interstate compacts for businesses. So that way it helps a particular industry, such as psychologists, be able to practice in different states through certain licensing compacts. So the point that you mentioned, especially regarding the New Hampshire bill and it being based off Connecticut, I mean, I'd have to say it's definitely an interesting idea. And maybe we have to have a conversation with our neighbors in Connecticut, see how they're doing it. So that way, at least everybody's on the same page, how we're handling this issue. Because, I mean, as you mentioned, driving through New England, I mean, you could go through 3 or 4 different states in just a couple hours. So having our bills be somewhat uniform would definitely not be a bad idea by any means. And especially if it still covers privacy, which is the goal here. It's not that anybody doesn't want to protect the consumer. It's just we want to do it in a way that is least damaging the businesses, but also is simpler to codify where everybody can understand it.
Absolutely. And we have supported some of the interstate compacts, particularly in the realm of telehealth. I think it's a great model. Obviously, in an ideal world, we'd have a federal privacy law that covers everybody. But in the world we live in, the next best thing that we could hope for, particularly in this region, is something where it's interoperable among our neighboring states.
Well, thank you very much.
Other questions? Chris, do you know lawsuits that were filed, private right of action suits that were filed in Illinois? How many of those have been dismissed because they're frivolous?
Yeah, it's a good question, Mr. Chairman. I think I do believe that SPSC may have a breakdown of that, of the more recent numbers there. I will say that I think it's a small handful that have actually made it through to a actual judgment. There's a massive a group that were settled largely because of disproportionate cost of discovery on the defendant. Companies just recognize that regardless of any wrongdoing or not, it's going to be cheaper to just settle. And then, yes, as you mentioned, there's another group that have been dismissed. But again, it costs up to $1 million for a company just to get to that point. So I don't have the actual breakdown of the ratio, but that's something that I can work to get for you.
Thank you. Other questions, committee? Great, Chris, thank you for joining us.
Thank you very much for having me.
Yeah, Chris is on. Chris, good morning.
Good morning, Mr. Chair, members of the committee. My name is Chris Oswald. I am the head of law, ethics, and government relations, also an EVP at the Association of National Advertisers. And I'm pleased to be with you today. I wish I was actually with you in person up in Montpelier. The ANA, by way of background, is the nation's oldest and largest advertising trade association. We count over 1,600 members, including advertisers, nonprofits, media companies, and other marketing solutions providers. And those 1,600 members represent over 20,000 brands and over 50,000 industry professionals. So if you can think of a company that advertises or markets, likely they are a member of the ANA. And to give you a little bit of context into what advertising means to Vermont, I provided your committee assistant, Andrew, with a couple of handouts. But specifically, we did a study a couple of years ago. Actually, we commissioned an independent study along with some other organizations that found that over $11 billion in economic activity can be traced back to advertising. That is, advertising helped generate $11 billion in economic activity. And moreover, over 60,000 jobs, that's about 20% of jobs in Vermont, can be traced back to responsible advertising and marketing. And that's about one job out of every 66 Vermont jobs are somehow related to advertising or marketing or somehow supported by advertising and marketing. And so with that as sort of a context, we want to appreciate your time for us to kind of weigh in a little bit on some of the concerns we have with H121 as it's drafted. And we're going off of the March 31 amendments, which we think are the last drafted amendments. But that said, at the outset, I'll simply say that ANA strongly agrees that Vermont consumers deserve meaningful privacy protections supported by reasonable governmental policies. Such protections should, however, be aligned with the privacy rights in other states. And it simply makes sense that we want a privacy support structure that's easy for consumers to understand, and it's straightforward enough for companies to comply with. And we encourage the General Assembly to work to that goal, especially this committee. And for a number of reasons that I'll go through here, we are a little bit concerned with the way that 121 is currently structured, because we think that it is a bit confusing. It has some deficiencies in definitions, and it could really use some additional work to achieve that goal of clear, meaningful privacy protections that is straightforward enough for businesses to comply with. So with that, I'm going to go through 5 different points for you, and then we can have, I'm happy to field your questions as well. The first point is that 121, as it's currently crafted, it combines discrete elements of existing privacy laws with new standards that are unprecedented, which make them unclear and operationally difficult to comply with. So we all agree, I think, that uniformity among state privacy laws, and again, having a straightforward privacy schema is in the interest of Vermonters and Vermont businesses alike. But 121 cobbles together elements of existing laws and creates these new requirements that no other state has confronted before. For example, while the bill's opt-outs for sales, targeted advertising, and profiling exist in other laws, its opt-outs for predictive analytics and tracking exist in no other state. The bill provides definitions for some of its opt-out rights, creating further confusion about how such opt-out rights are supposed to work together. The bill creates an entirely new entity of data collector and regulates those data collectors differently than the existing definition of data brokers. Furthermore, the bill includes outdated concepts like do not track. The structure of do not track is fundamentally inconsistent with other approaches to privacy in other states. So Vermont, in our opinion, should try to seek harmony and harmonize these inconsistent definitions and provisions rather than trying to cherry pick provisions from certain states and cobble together what would turn out to be a confusing provision for privacy that makes it very difficult for companies to comply with. So that's point number one. Point number two, the bill adopts outdated provisions that have been amended out of other laws or fixed by way of regulation. And specifically, 121 draws certain terms from older versions of the California privacy law. Now, California has passed 2 laws relating to privacy, and it's just released regulations. So it's understandable that some of these terms, may have worked its way into 121, but specifically the provision that would require consumer notice at or before the time of personal information collection was amended out of the California law by regulation. California recognized that the issue of companies that don't have a direct relationship with consumers providing notice at or before the time of personal collection, that was going to be operationally impossible for them to comply with. California recognized it and fixed that provision via regulation so that companies without consumer relationships directly have other avenues to provide notice requirements and responsibly use data. So again, 121 would do better to be reviewed in a study to make sure that that outdated provision is taken care of. Thirdly, the bill's internal consistencies and broad applicability present serious challenges for compliance amongst businesses and nonprofits. Vermont should take the learnings of other states that have already passed privacy legislation, as we've heard before from my colleague and peer over at TechNet. H121 H121 has individual data broker opt-outs, and they appear to apply to data collection, sales, and even deletion, but the bill's general opt-out provisions don't clarify which activities a consumer may opt out of using the data broker opt-out. Moreover, the bill would apply to any person conducting business in the state, even small businesses that process very small amounts of data or de minimis involvement in consumer data. So small companies and large companies alike would be subject to a confusing web of compliance ambiguities if 121 is enacted as it's written. Larger companies may have the resources to put in the processes in place to comply with it as written now, but small companies will not, and that opens them up for the private right of action, which I'll get to in a moment. Fourthly, the bill contains standards that would harm consumers and unreasonably restrict businesses. Vermont should encourage responsible use of data to benefit consumers. And as it's written right now, it unreasonably restricts data collectors from responsibly using or retaining data. For example, if they can't determine the initial purpose, notice, or consent required to collect such information, Vermont's residents would be largely impacted because of the open and free access to internet resources and content would likely be diminished as it's currently as 121 is currently written. So all of the news, all of the entertainment, videos, games, and more is powered by advertising, which leverages the responsible use of data by third-party data collectors. And the restrictions on that would definitely impact Vermonters able to access that low cost, no cost content on the internet. And just by way of perspective, a study was conducted last year using 2017 dollars, estimates that each individual in the country gains about $30,000 worth of value every year in free content and other benefit that comes from the free internet. So that's definitely a concern. Finally, as was mentioned before, a private right of action really should have no place in any privacy legislation. 121 permits, as it's written, private litigants from bringing suit against even the smallest companies for even technical violations of what would be law here. And in so doing, it jeopardizes companies, both large and small, with a very costly lawsuit. And as you heard from our previous speaker, what usually happens with this is a lot of these cases never go to trial. The threat alone forces companies, especially smaller companies, into settling what may be meritless suits. Even if they are, even if they do have merit, it just becomes overly costly. That said, we believe that, again, it's more important to have enforcement for a law like this housed within the Attorney General, because the Attorney General's office is generally the entity within a state, especially in Vermont, that can make the better judgment calls as to whether a consumer was actually harmed or if this is just a money grab by a plaintiff's attorney. And they can actually make sure that enforcement is done that doesn't inhibit innovation and doesn't restrict companies from doing right by their consumers. And with that, I want to thank you again for your time. I'm happy to take a few questions from you.
Questions for Chris?
Do you have questions? Hi, Chris. Thank you. You mentioned something about advertisers and responsible use of data. So what does the Association of National Advertisers do to support?
Sure. So over a decade ago, we, the ANA, along with our sister advertising trade associations, we created the Digital Advertising Alliance. And the DAA, again, having been in existence for over a decade, I think we're in our 13th year now, they created a opt-out choice system for tailored advertising. That is, if you don't want an advertisement that is tailored to your interests, your perspective, and advertising items and services that are of interest to you, you have the ability through the Ad Choices program that's been promulgated by the DAA to opt out of data-driven advertising. And it doesn't mean you're not going to get any advertising. It just means you're not going to get smart advertising. You'll end up getting advertisements for a lawnmower if you live or you run the risk of getting advertisements for a lawnmower, even if you live in a condo or an apartment and don't have a lawn. So that's a really great example of how the industry has responded to consumers and providing choice and providing their options for privacy. And in so doing, that program has been applauded for years by the Federal Trade Commission as a great option for consumers to exercise choice when it comes to advertising while still being friendly to businesses. So that's one example.
So that's not actually anything about responsible use of data. That's about giving consumers an opt-out of getting certain advertising, right? It doesn't do anything to protect consumer data.
Sure. So
that was my question. Thank you.
Thank you.
Hi. So quick question. Our previous speaker referred to a New Hampshire privacy bill that was lifted from the Connecticut version, which I find very interesting because philosophically New Hampshire and Connecticut don't always agree on things. So what's your perspective on the Connecticut and New Hampshire privacy legislation in terms of the way that they're enforced as opposed to the way this would handle it?
Well, quite honestly, our perspective at the ANA is that we are for a national data privacy standard, and we're working towards that. We're working towards that goal, and we've been engaged in all of the state privacy proposals throughout the country, not just New Hampshire, not just Connecticut, although we're active there in Connecticut and in all the other states that have viable privacy laws. And, from that perspective, that's what we support, is a national system passed by Congress that creates a uniform, understandable privacy protections for consumers across the country, because we think that that's, what's best for consumers is, one clear-cut rule that everyone can understand, irrespective of where they happen to live. In the meantime, we look to harmonize what's developing now, which is the patchwork quilt of state laws, which is going to be very difficult for consumers to understand their rights specifically, depending on where they happen to be. And it's going to provide a vexing compliance standard for companies as well. So that's what I'll have to say about the other states' privacy proposals.
No worries. I was just curious because one of the things that, as mentioned previously, as mentioned in the past, is the compliance aspect is the most difficult part, and that's something that we're trying to figure out here is just making that balance between consumer protection, but also making sure that businesses can actually have reasonable compliance with it, because we want people to be able to have their businesses advertise their products, and we also want individuals who are those consumers to have their rights respected. So going back to the patchwork, I guess that was originally the question, because I'm just curious about how states working together until a alleged federal federal proposal goes through, which could be 5 years now, it could be 10 years from now, it could never happen. So states right now kind of have to pick up the slack until the federal government decides to take up this issue. So I was just curious, especially from your advertising perspective, how interstate work would be beneficial for everybody.
Yeah, no, and I agree, and quite honestly, Representative, I think that one of the things, that begs for Vermont to do it right and to take time and to engage in the study. I was engaged with the study that the legislature undertook when it came to the data broker registry a few years ago, working closely with former AG Donovan's office. And, I took several treks up to Montpelier and provided testimony. That was a very thoughtful way of engaging in what was, at the time, I think it was the first sort of register that we saw in the States. And so from that perspective as well, we have a lot of differing privacy laws. We try to harmonize them within the states in the effort to provide a national law. But at the same time, there's a lot of, I'll put it this way, there's still a lot of rough edges within 121 as it's amended. And I think the Vermonters would do well if you as their representatives took your time, do a deep dive study of what's happening in other states and figuring out what's best for Vermonters in looking at what's actually in other states.
Perfect.
Thank you, Chris. Playing devil's advocate around the private right of action, one might argue that in a smaller state like Vermont, that does not have an attorney general's office as well equipped or as well funded as, say, New York or another large state, that private right of action enables Vermonters and the state of Vermont to enforce the laws that it has on its books.
Mhm.
So, you know, I see it as another means by which we ensure that we have businesses complying with what we want for our consumers and our residents. And so I'm just curious as to why such opposition for the private right of action.
Well, I think, again, it's in some cases where there's actual harm, there's actual violations that cause harm to consumers, the merited lawsuits, right? That is, in a perfect world, that would make sense. However, in practice, what we've seen, not just in this space, but in plenty of other spaces, is a chilling effect. You see a chilling effect of plaintiffs' bar trial attorneys that file lawsuits, merited or not, that can take down an entire enterprise just from the cost of the suit itself. And I don't think that Vermonters want their small businesses under threat constantly by what might likely be meritless suits. And rather than fighting those suits, a lot of small business and medium-sized businesses as well would choose to settle and pay off a trial attorney rather than taking the suit to trial. And in so doing, there's no guarantee that they would change their practices. That said, that's money rather than going to plaintiffs' attorneys and trial lawyers. That's money that can be better spent back in the business, achieving and promoting privacy protective practices within the business. And quite honestly, if there are cases out there that do require enforcement, again, on balance, it's better for the AG to bring those suits and to levy fines against companies that do flaunt privacy protections and that harm consumers. And the AG is a better referee, I would think, to bring those cases rather than the constant threat of meritless lawsuits by trial attorneys who would get rich off of them through settlements.
For your answer.
Emma?
Thank you. I'm just wondering, Chris, because it sounds like you're very engaged in all the states that have been trying to develop this. And so were you involved when the AGO's office was starting to really look into this sort of at our direction back in 2021? Were you giving input during that process?
We were aware of it, and I don't believe that we commented on anything until we actually had a proposal. We've filed our first comments, I believe, back in February when the bill was released. But we have engaged in other states. We'd be happy to engage. Should 121 be looked at further through a study, happy to do that. We did that previously when we were discussing the data broker registry.
You are putting out the study thing, which is often a way for us to not actually address the policy question at hand. And so I tend to not love studies because part of our job is to look at what's already been done before. And we did study it through our AGO's office. And so I think that's the point where stakeholders could really engage and provide the input necessary. And I'm disappointed that you all didn't use those opportunities. I'm not done yet. Hold on. That opportunity to give that feedback, because that's really how our part-time legislature benefits, is when people engage in the process we set up and then give us that input on the front end rather than sort of reacting at this point in the process. So I just wanted to see if you had taken up the opportunity with those several forums the AGO had done in the last couple of years. So I'm all set. Thank you.
Other questions? Okay, Chris, thank you very much for joining us this morning.
Thank you very much. Appreciate your time.
So committee, we don't have any further witnesses on this one until this afternoon. And our next subject on 434 is at 45, so we have some time. or you have some time to do some of your outside work. Before we sign off, so I wasn't here for discussion on the catalytic converter fees. I did mention that it made the newspapers in Caledonia County. There was one piece that Todd Wright talked about, that he talked about, and I haven't looked at the video yet, but talked about vehicles that might have 2 catalytic converters.
Four.
Or
Or a Ford Explorer.
And F1.
Did anybody, so do they generally lose all 4 if somebody's ripping them off?
We didn't get quite into that detail.
We were shocked they had 4.
Yeah.
Like
It's the
what?
first I've heard that.
Yeah.
Even so, I think,
Yeah.
I mean, I think the bills has a design, so it would, the way it's designed, I mean, you can bring 1 in every day without having to, you know, put the VIN numbers on, but I mean, just write the VIN number on all 4 of them. I don't know that we can think about changing that. Thoughts are, you've heard testimony.
I agree with that. If it's your car and you have the proof that it's your car, it's very easy within the bill to show that it's your car and that you, yeah, so I agree. I spent a lot of time thinking about that.
Yeah. Did anyone ask the question of, to both of them, the state trooper and to Todd, whether they're aware of the underlying statute of the requirements, like for Todd, does he keep records now that he's required to keep? And I wonder if the state trooper knew that there were already laws on the books that they could go to those to try to track down, you know, go to the salvage yards that are out there and try to track down what's going on, whether they know that there are supposed to be records kept.
I did ask the state trooper that, just if he had a relationship with salvage yards. He said that he wasn't on patrol as much as he used to be, but when he was on patrol, he was fairly actively engaged with the salvage yards in his area. But that it was something he didn't want to speak for other law enforcement to know whether they.
Yeah, it's one thing to be engaged in chatting with them, but I mean, do they know that they're required to keep records, and do they go in and check those records from time to time?
We did hear from Rory T, Mr. Chair, about then it would be helpful if some clarity around the quality of records being kept was either put into this bill or something else in terms of, he did mention that, if I recall, that there be more specificity around what is maintained and for how long and what manner, much like the Public Records Act, I would imagine.
Do we need someone to develop a template that goes out to all of them that they can download off the internet, a PDF?
Sure.
That they download and it's got, you know, name and, you know, government ID, that type of thing, address, phone number.
I don't know if that made the Caledonia record either, but Mr. Wright also mentioned that he has a sign that makes clear that
The best line I've ever heard.
state law requires him to have ID, and he thinks it's interesting that state law doesn't actually require him to do that yet.
Yeah,
But he does have
actually it
that.
does.
Does it?
Or
It
he
does.
said that there was a point that he had that said that state law required him to do something that he's not actually required to do at the moment.
Oh, okay, because he is required to take ID. I mean,
I think
he's got a spot where people can go and bring their medals and everything and donate it. So I'm not worried that people are gonna go rip somebody else off. and
Donate the
donate it
Cadillac.
after that, right? So that's not a problem.
Yeah.
But you know, where they come in and you know, bring a bunch of metals, and especially if they bring a bunch of copper or bringing catalytic converters, there is a requirement for them to look at their IDs and jot it down and get their address and all of that. So, you know, there's a lot of stuff on the books already, and it's just kind of magnifies it a little bit more. But maybe we need to have gotta figure out who is the right, or what agency or department is the right one to provide that uniform, form that they could use.
Kind of surprised they don't have one. It seems like that would be in any kind of organization thing. If you require people to get data, you give them the form on what you want to build out. So I'm just surprised they don't, but maybe it's just the way the state works.
Well, I don't know that we really settled on an agency or department that,
That's it.
you know, has oversight. I think we just assume that, you know, law enforcement would, but,
Yeah.
you know, is it public safety that should, you know, come up with the form and then it just lives on their webpage?
Yeah.
And then salvage yards can go there to get the form. And generally, you know, in any business, there's a form that they ask you to do. They have it on their webpage that you can download. So,
A question that's been nagging me is who would be the responsible party to engrave or write VIN numbers on the catalytic?
the person that's gonna turn them in.
Wants the Sharpie.
Yeah, for us, we had talked about just, you would only really need a Sharpie. So you don't necessarily need to engrave. But the idea being that, you know, at different points at the federal level, they've talked about engraving going forward. And so that would be a substitute if that ever actually got enacted or passed or anything like that.
And would they have to provide some proof of ownership, like from the car?
Yeah,
So
bill of
that's
sale,
gonna be in there.
registration.
'Cause I didn't recall.
Yeah, unless you're a, you know, auto mechanic, you know, repair facility that takes a converter off, that they can just jot down. All they need to do is jot the VIN number down. They don't have to prove that. I mean, they're already known to be a repair facility. But as long as that VIN number is associated with the converter, then they're.
So the one thing I would express in particular, especially with people that in the automotive hobby may have parts cars that they source from, that they eventually, you know, they get the parts from it, use it on a different vehicle, and then scrap the rest of the vehicle. So the thing that has me concerned about, bill of sale would make sense to me. So at that point in time, if you're getting rid of a vehicle, you have bill of sale, that's fine. But you have some vehicles that, especially if you're taking apart a parts car, I've taken apart vehicles that haven't been on the road since the 80s. So some of these vehicles will not have titles. Some of these vehicles will not have current registrations. And some people have purchased these vehicles, I've done it myself included, where I have no intention of ever putting it back on the road again. So
I actually brought that entire point up with the mechanic I spoke with who was helping me with my car on Monday. And he said, in all cases, if you were to buy a car, even if you're buying one like undrivable car from, you would just, even a handwritten agreement between the people that you, say if you were to purchase an undrivable car from me, and I would just say I had no records because it was an old, maybe I came with a piece of property that I bought or something, and it just happened to be in the yard, and so it would just be a document between me and you and signed. And he said in most cases, just a casual like that
casual bill of sale
is enough.
Okay.
It has to be that, because I'm just thinking about like, I've purchased a property before where there were cars remaining on the property, and so but it came with my property. I have all identification that was a description of the property, and I could just say I'm selling this heap to you, and that you would have it for parts.
Okay, yeah, and that's just one thing I'm just trying to be careful of, especially if you have situations where somebody has something for a long time, and the state of Vermont doesn't generally reissue titles to vehicles over a certain age. So my concern is they have somebody with an older vehicle that may not necessarily have the bill of sale for it. At that point in time, are they going to self-prescribe a bill of sale to the scrapper? And those are just the issues I'm just trying to make sure to get through so that way people don't end up getting stuck with a piece of property that they can no longer get rid of. So that's just me doing the devil's advocate, looking at the very obscure and most likely not to happen scenario, but still a possible scenario.
That's why I brought it up with the
Yeah.
mechanic I was speaking with, because I said it should never be a problem.
Okay, perfect.
So,
Thank you.
sorry, Jared. To the scrap metal processors statute, it only requires that they keep their records in a permanent ledger, the identification information of the seller, the time and date of the transaction, and the license number of the seller's vehicle, and a description of the items received. But
Simple, okay.
permanent ledger, that sounds, I don't know, antiquated, but I could be wrong.
Okay.
I think we should have one. Title 9.
Okay, so let's come back before you go, Emma, we'll come back at 10:25.
10:25.
David can come in at 10:25, he's gotta go at 10:40.
Makes sense.